Hello, this is Rick Durfee. Today we're going to talk about how to avoid probate. And one of the first things we have to address is, well, what the heck is probate? A lot of people have some great misunderstandings about that. Probate is, first of all, not a tax. Some people think, oh, it's a tax, I have to pay a tax. It's not a tax. And it has a long and interesting history. It has been the practice of humans from the dawn of time to rip off dead people. Dead people have no natural defenses. They can't fight back. If you want to steal their stuff, they can't stop you. So people do that. And we have devised, most cultures, most legal systems have devised various ways to make sure the property goes to the people it should go to. And one of the things that we have done in our society, it's a literate society, it's based on writing things down, is people write down what they want. They write it down in a document, and that document is called, well, what I want. What I want is my will. That's my will. So we call that a will. And sometimes it was something people would write just before they die. So it would be their last will, the last thing they want, their last will and testament. And what a probate is, interestingly enough, is a way of proving or validating or verifying the last will and testament. So it has developed in our legal system as a court proceeding, actually a type of litigation, to determine, is this will valid? And if it's valid, what does it mean and how are we going to implement it? So it necessarily involves going to court. And it is, by the way, in that court proceeding, unavoidably adversarial. All the family members, the heirs, the people who might get something under that will are given a legal notice that says, in complicated legal language, basically, hey, you want to fight? If you want to fight, you better fight now or you lose your right to fight forever. So people will come and say, well, I really don't want to fight, but I don't want to give up any important rights either. So they lawyer up. And then if you get more than one lawyer involved in the deal, guess what happens? It's a fight. And people spend a lot of money on legal fees and it takes a long time. Best case scenario, in most situations, if there's a probate, it's going to take a year. Just because there's various notice requirements and statutory periods that have to run to give creditors and things like that an opportunity to make their claims. So how the heck do we avoid this probate process? And I don't mean to be too snarky, but one way is never die or never have anything. So if you can either not die or die broke, you can avoid probate, but that's kind of silly. Who wants to do that? So here's the basic principle. Lots of people talk about these specific things, but let's understand the principle. You can avoid probate by causing your assets to be subject to a contract that controls what happens to them over time. A contract. And there's a lot of ways this happens in our modern society. And I'll give you a very common one that people encounter all the time with just about every type of financial account, a bank account, a brokerage account, an annuity, a life insurance policy. You can name a beneficiary. So a beneficiary is a person you name, and by contract, when you pass away, that named beneficiary gets whatever the asset is. So they're going to get the bank account, they're going to get the life insurance policy, they're going to get the annuity, they're going to get the retirement account, whatever it happens to be. If they're the beneficiary, they get it. Now, an important note I want to make on this, especially if you go to a bank and you name a beneficiary, those are sometimes called a pay on death beneficiary, a POD beneficiary, or a transfer on death, a TOD beneficiary. It is super important that you tell the people involved, you need to go to this bank when I pass away and claim this account, because the bank is not going to come find you. They don't mail out letters. They don't tell the beneficiaries. The beneficiaries are on their own to come to the bank and say, hey, I think my mother passed away and there's a bank account here and I'm the beneficiary. Please give it to me. And the bank is going to have requirements. They'll typically require a death certificate and valid ID and all that kind of stuff for you to prove who you are, that you're not some interloper coming in and grabbing the money when you're not entitled to it. But you'll jump through those hoops and you'll be able to collect the money if you are the pay on death beneficiary. Now, I want to tell you, as a lawyer, we've had the experience of people discovering years after the fact, oh no, there's bank accounts. We had one case, there was over $1 million in bank accounts, and it had been sitting there for years and nobody knew about it, and they actually found it by accident. So make sure somebody knows about those bank accounts with the POD or TOD, pay on death beneficiary designations. So that avoids probate. That beneficiary, we don't have to go to court, we don't have to prove a will by law, by statute, by contract. You've designated a beneficiary and the beneficiary is able to claim the property. Another device, and I like to talk from general principles and then drill down to specifics. Another device for avoiding probate is joint ownership. Now this is tricky, and people do this without fully understanding the consequences. So here's an example. Joint ownership of a piece of real estate would be typically something called joint tenancy with rights of survivorship. And most states permit this in one form or another. There's some little variations from state to state, but most states permit this. So you can own your house with one of your children or your brother or your sister or your best friend or the person you're living with or whoever as joint tenants with rights of survivorship. And this means if one of those people that is a joint tenant dies, the other people automatically own it. Automatically. It's just automatic. It happens just automatically. And sometimes to perfect title, you have to record a death certificate or something like that, and that also varies from place to place. But the transfer of ownership occurs automatically upon death. Now here's the hazard with that. Although it works and it does avoid probate, it has some hair on it. And there are some tax issues. There's questions about, well, who contributed to the purchase of the property, who gets to recover the cost basis upon sale of the property. Is there a step up in basis on the property? Or if the joint tenant owns some percentage of it because they contributed to the purchase, do you not get a step up on the living one's share and only on the dead one's share? So there's some complicated tax issues that can come up with joint tenancy property. That's an issue. But another huge issue is when you own property as joint tenants with another person, that property is vulnerable to the creditors and liabilities of all the joint tenants. So a situation I saw a number of years ago, and I've actually seen the same thing in various forms happen many times. A woman had a house. She wanted to avoid probate. It was her only asset. So she put the house in joint tenancy with her daughter, who was her only child, thinking, oh, this is great. When I pass away, my daughter will get my house automatically. We won't have probate. Well, the daughter's marriage went south. And because the daughter acquired the joint tenancy interest as a gift from her mom, so to speak, it was not a marital asset. But when it came time to divide up the assets between husband and wife, they fought over that, as you might not be surprised to hear. And when they calculated what's the daughter's half, they kind of included that half of the property in the daughter's half of the marital divorce. So the daughter ended up with her joint tenancy interest in the house, but as a consequence, her interest in the marital assets were reduced because of the settlement with her ex-husband. And then the other tragic thing is, in the settlement, the daughter was liable for all of her medical expenses. And they were extensive, and there was a lot of bills. And so there were creditor claims, and those creditor claims were able to reach mom's house and became a lien on mom's house. And so mom's house and all the equity that she had was impaired by the liabilities of the daughter that she put on as a joint tenant. So although joint tenancy works, it's dangerous. In rare circumstances, we generally recommend do something else. So some other variations of this contract thing. A lot of states now, with real estate in particular, recognize various forms of what is commonly called a beneficiary deed. And this is a deed where, okay, you're going to retain the ownership completely during your lifetime. You can buy it, sell it, but you've named a beneficiary. Again, kind of similar to the bank account thing. You've named a beneficiary. So upon passing, that beneficiary automatically becomes entitled to the property. And this is actually specifically designed for smaller, simpler estates where we just want the property to pass to this family member. These two are great and they work in the right circumstances, but they can also backfire. And I'll give you another example. This came out of recent experience with the pandemic. Lots of people were sick and lots of people passed away. We had a situation where we did not set this up, but we came in after the fact to clean it up. A father named his son as the beneficiary on a beneficiary deed, thinking, well, I'm older than my son, I'm going to die first. And then the son will inherit my property, and then he can figure out what he's going to do with it. Well, guess what? The son died first, and then the father died a week later. So who gets the property? Turns out, well, it's back in Dad's estate. We have to go to probate for Dad's estate. Dad died without a will because he thought, oh, I'm being so clever. I have a probate avoidance device with my beneficiary deed. It's going to go to my son. So now the estate is what is called intestate, which means you died without a will. So we're back in court, back in front of a judge, spending thousands of dollars and taking a year to get the judge to approve and tell us, okay, this is who's going to get the property. And guess who's going to get the property? The dead son's children. But they're not going to get it until after spending a heck of a lot of time and money. So even that beneficiary deed, although it is a good device and appropriate to use under some circumstances, can backfire. So the one last thing I want to mention, well, two last things actually. Sometimes business entities, and this again varies from state to state, some business entities by their terms, so the operating agreement of an LLC or other things, can provide under the terms of the contract that in the event of death, this interest goes to so-and-so. And that is also a common device. That's a little more complicated and usually is involving business entities. And there are some state-specific rules that you kind of have to watch out for. So you need to find out your local rules wherever you happen to be dealing with that issue. So now I want to get to the big grand poobah, the granddaddy of all asset probate avoidance devices, and that is a trust. What the heck is a trust, and why and how does it avoid probate? Remember in the very beginning of this video we said the way you avoid probate is you have a contract that controls what happens to a particular property or asset over time. That's the simplest definition of what a trust is. A trust is a contract that controls the disposition of property over time. It can control that property during your lifetime so that you create the trust, you're the grantor or the settlor, the person who created the trust. You're the trustee, the executive that runs it, you're in charge, you're in control. You're the beneficiary. That's the classic revocable living trust model. The trust owns the property, but you're in control of the trust. So it does not, by the way, change your income tax liability. You're still going to have to pay income taxes. You still file an income tax return. So it's not an income tax savings device, but it is a probate avoidance device. Now, because the trust owns the property, and it can be your real estate, your bank accounts, life insurance, and other things, because the trust owns the property, in the event of your passing, which, by the way, is a when question, not an if question, the probability of death is, drum roll please, 100%. You're going to die. By the way, there's a great William Shatner song. I'm just going to promote this here because I love it. It's called You're Gonna Die. I encourage you, look that up and find it. It's pretty funny. And it just comes right to the point. We're not getting out of this life alive. You are going to die. So when you die, if you have established a trust, and if you have funded your trust, successor trustees will be able to come into play and cause the property to go to wherever you've said it goes under the terms of your trust. Now, that avoids probate. Couple of steps for that to happen. The trust has to actually own the assets. Some years ago, I had a lawyer say, oh, well, we're going to form this trust for you, but we're going to leave your assets out on purpose because you have a pour-over will that will put your assets in your trust when you die. Well, what does that mean? Let's translate that into practical terms. It means that, when you die, the trust doesn't own anything, so we didn't avoid probate. Now we have to go to probate. And yeah, your will's a pour-over will, so that means it says, take anything that's not in the trust and pour it over into the trust. So the assets are going to get into your trust, but the mechanism by which they get there is probate. So that attorney was just crazy, weird. I think he was double dipping, candidly. Sadly, the people that were involved ended up paying for that transfer of property from one generation to the next more than once. They paid for the trust, then they had to pay for the probate, and they had to go through the costs and expense and delays that the probate had. So the trust has to be funded. You actually have to put your real estate in the trust, your business entities in the trust, your bank accounts in the trust. Now let's talk about life insurance, because this is a big one that a lot of people just get messed up, including a lot of life insurance professionals. Hey, you life insurance pros out there, pay attention to this. They'll tell you, oh, you don't need to use your trust with your life insurance policy, just name a beneficiary. And while that's true, let's think about it, because we've had the experience. In fact, I'll tell you the most common one. How do we end up probating life insurance? What? Life insurance is supposed to pass probate free. Well, how does it get probated? And we've done this over and over again where the daughter comes to us and say, oh, my mom and dad were horribly killed in a common accident, and they had all this life insurance, and guess who the beneficiaries were? Each other. Daddy's life insurance, the beneficiary was mommy. Mommy's life insurance, the beneficiary was daddy, and they both died. So what do we have? Life insurance policies paying to dead people. Now that's a little harsh, I get it, but what does that mean? Double probates for the stupid life insurance. So if you own your life insurance and you have not properly designated beneficiaries, it can end up being probated. The same thing happens with life insurance paying to a son or a daughter, a child, a family member, and that person is dead. Now we're probating it. If the life insurance pays to a trust, so the beneficiary of the life insurance is a trust, the trust is going to manage all those issues of what if somebody dies unexpectedly out of order of age? Oh, it wasn't the old person that died, it was the young person that died. Now what? Well, the trust can manage all that. It can control or dictate, or you can have a plan mapped out in advance. Okay, yeah, I want this to go to my spouse, but if my spouse is dead before me or at the same time as me, well, then what? You build that plan into the trust. So the trust is a very powerful device for you to plan and put into effect what you want to have happen with your stuff over time. And here's the deal. Somebody is going to plan what happens with your stuff. And if you don't do the planning, if you don't set it up in advance, other people are going to do it for you. And the ones most likely to do that are the politicians, the IRS, and the attorneys. And just saying, those people have a very different agenda as to what ought to happen with your property than you do. They want the property to go to places that may be different than where you want. So I encourage you, take control of your life, take control of your assets. This is a grown-up thing. If you're an adult and you own stuff and you have family members that you want to care for, it's highly appropriate that you set up appropriate planning in advance so that you have beneficiaries designated, you have joint tenancy or deeds, or you have beneficiary deeds, you have appropriate contracts, and where possible, you have the grand poobah, the big daddy trust. You have a trust that owns your assets so that in the event of your passing, there's no probate. Now, I want to also say, probate gets a bad rap. It's a bad thing. Well, it's not really a bad thing. It's an expensive thing. The ultimate social goal of probate is to protect widows and orphans from getting ripped off and having their inheritance taken by people who are not entitled to it. So probate has a valid social benefit. It, for the most part, gets the property where it belongs. Sadly, the part that's bad is because it has to go through the court system, and because the court system is complicated and we involve lawyers, by the time it gets through that filter, there's not quite as much there as there was in the beginning. So if we can avoid that administrative overhead and expense of the probate process and get the assets where they belong with less money, less hassle, less aggravation, we've done a good thing socially. We've done a good thing for our family. We've been responsible stewards of what we have been blessed with. So that's it for today. Some lessons on how to avoid probate. I hope this is helpful. Come see us if we can help you do this. We love to help people work through these issues. That's it for today. Thanks.